All right, welcome back. We are at the halfway point. So after that break, I hope you are all recaffeinated and stretched out, ready to begin again. Our next session, which we've entitled the East Coast, West Coast Squeeze, gives our experts from our New York, Seattle, and Southern California offices the opportunity to tell some of you what you already know but wish you didn't, and others of you what you need to be aware of, because unfortunately the coasts often are a precursor to what we see here in Minneapolis. Shevon Rockett, one of our presenters, is a partner out of our New York office. Aaron Goldstein is a partner from Dorsey's Seattle office in the L&E Group, and Gabrielle Wirth is a partner from Dorsey's Southern California employment practice. Now, as you might imagine, having experts from both coasts present at the same time can be a bit of a logistical challenge, and now is no exception to that. So the next hour is going to be presented to you by way of a pre-recorded video. We were able to get Aaron and Shevon and Gabrielle together early to record this because we really wanted to have an opportunity to share their perspectives on their worlds with you. So with that, we will hit play, and I will hand it off to a virtual Shevon Rockett.
Thank you so much, Ryan. And again, welcome back from the break. First, I would like to apologize for not being with you live today, but one of the few benefits of us all working remotely is that I magically am able to be with you at the CLE and taking a deposition at the same time. So my apologies, but looking forward to presenting to you today. So let's jump right in. For most areas of the law, we can look to federal standards and use them to set our business policies and procedures across the country. But of course, we all know that isn't the case with employment law. The standards vary greatly across jurisdictions. And so what we're going to do in the next 50 minutes is highlight some, not all, of the key differences in some of the coastal states, which tend to have more robust labor laws. So I'm going to take you through some topics related to the East Coast and highlight some areas in New York and around the Northeast and Mid-Atlantic region. And then Gabrielle, being the incredible switch hitter that she is going to continue with that theme with highlighting some additional New York topics, and then turn to California. And then Aaron will focus on Washington. So between the three of us, we hope that we can cover, like I said, most or many, but not all of the key trends that are happening in those regions, and help those of you that are currently operating in those regions, thinking about operating in those regions, or hoping to adopt policies that are in line with some of the most robust standards around the country, giving you things to start to think about with respect to those coastal states. So first, we're going to turn to the paid sick leave. To the next slide, please. Now, this is something that's probably more of a boring topic that most folks are familiar with on some level or another. But of course, it's highly relevant given that we are in the middle of a pandemic. So the slide here highlights some of the standards for the Northeast and Mid-Atlantic region. As you can see, the exact number of hours that an employee is entitled to receive for every hour of work varies. And for Maine in particular, it's not just for sick reasons related to an illness or sickness. It can be for any reason. Most states, whether you have to have paid leave versus unpaid leave, it depends on the size of your business and also your income. Another thing that you must consider is about carryover and accrual. In most scenarios, carryover is unlimited, but can still be capped based on the annual accrual caps for a particular calendar year. And many find that front loading the full amount of leave at the beginning of the calendar year can be helpful in eliminating the need to track carryover and accrual. There's also waiting periods, and those vary by state. The longest is Vermont, which allows for up to a year. So the employee would have to work for up to a year before they can take their accrued leave. But as I said earlier, it varies by state. And you'll notice that New Hampshire and Pennsylvania are not up here because there are no statewide laws with respect to this topic. Next slide, please. In turning to exactly what's permitted permitted uses for the paid sick leave, the key uses are listed here, and I'll say that I think the first two are ones that most are familiar with, and that's what they automatically think about with respect to paid sick leave, and that's an employee or a family member's mental or physical illness or injury. In New York in particular, that can be regardless of whether it has been diagnosed or requires medical attention at the time of the request. The second one would be with respect to care, diagnosis, treatment, including preventative care and routine medical appointments. And the third, I think, is something that people don't necessarily associate with paid sick leave, but that is for specified reasons related to domestic violence. Various jurisdictions have different ways of defining this. New York also includes stalking and human trafficking related to the employee or the employee's family members. In addition, it's worth noting that New York City has amended its Earned Safe and Sick Time Act to include all of the same things that New York State has, but also if the employer's business is closed due to a public health emergency, or if the employee's child's school or child care facility is closed due to a public health emergency. And Vermont and New Jersey have similar language about business closings. I know that we've already discussed today some of the COVID-19 related and specific litigation concerns, but it's worth noting that in New York and in other places, COVID leave is in addition to other employer-provided sick leave. Next slide. So now we're going to shift our focus to another topic that many may not be familiar with in this context, and that's reproductive health rights. Section 203E of New York State labor law defines reproductive health decision-making as included but not limited to decisions to use or access a particular drug, a device, or medical service. And this law prohibits the employee from accessing the information about reproductive health decisions without informed written consent, discriminating or taking any retaliatory action related to a particular decision of an employee, or requiring an employee to sign a waiver or other documents that purport to deny the employee the right to make their own reproductive health care decisions. And the law provides several examples, although I said, and it lists here on the slide, it's included but not limited to, but several examples, including everything from abortion and birth control to sterilization procedures and pregnancy testing and sexually transmitted disease prevention and testing. So there's a wide range of topics there that are included in what New York considers reproductive health decisions. The next slide. We're not going to read this, of course, but it's included so that you can look at it at your leisure after the presentations today. And it's a recommended insert for your handbooks with respect to notice for an employee's rights and remedies related to reproductive health rights. Next slide. So now we're going to turn to another topic that I think most may not be familiar with, especially if you're not familiar with labor laws on the coast, and that is Crown Acts, race discrimination based on natural hairstyles. And CROWN stands for Creating a Respectful and Open World for Natural Hair. This particular type of legislation is starting to gain momentum. New York is one of several states that have amended the definition of race to include traits historically associated with race, including but not limited to hair texture and protective styles, and also provides examples of what protective styles may be. in addition to the states that have laws on the books right now with respect to natural hairstyles, there are also about 20 cities or counties across the country, and they usually tend to be major cities, that have laws on the books related to Crown Acts. And the trend is, this particular trend is gaining momentum. In 2020, 25 states considered related legislation. And in September of 2020, the House of Representatives passed the Crown Act, and it's currently under review by the Senate. There are other states that are looking to take up legislation similar to this. And I expect that perhaps the first or second go round, these various acts will not become law, but it will likely continue to gain momentum. Next slide. So turning to a topic that, again, I think is gaining momentum and that many of us may be aware of, and that is salary history bans. And so just a brief overview, it generally prohibits employers from, among other things, inquiring about a job applicant's salary, wage, or history or benefits, and setting compensation. 19 states have some form of the ban. New York's is much broader than most, so we're going to spend a little bit of time talking about that. But I will also note that for various states, it may be that this particular ban is only related to the public sector. Some states have included the private sector as well. New York in particular, in addition to prohibiting inquiring about a salary history, it also prevents an employer from relying upon wage history. So you can still inquire about a salary expectation. You can also confirm a salary if it's given, the pay history is given to support a higher salary once the job is offered. But next slide, it's important to, when you're doing those things, you think about the parameters in mind, especially some of the more robust parameters in New York. So as I mentioned, not only can you not inquire about the salary history, but you also can't rely on it. And perhaps to make that less tempting, in addition to directly prohibiting asking about the history, you're also prohibited from trying to obtain this information. And that includes by searching publicly available records or requesting it from a current or former employer. And it really breaks down into three buckets where you can't rely on the salary history in determining whether to interview someone, to hire someone, or to promote an applicant or current employee. The New York State law does permit an employer to verify the salary history that is voluntarily disclosed only after an offer of employment with compensation has been extended. The city law, however, permits verification upon voluntary disclosure even before, and various states in the Northeast have different ways of approaching how to handle voluntary disclosure. But I will caution, even if you're in a jurisdiction that allows you to verify or further investigate after a voluntary disclosure, it's important to keep in mind that relying on salary history, even if it's verified, to justify pay differentials between employees who perform substantially similar work may still violate pay equity laws. So really, it's best to stay away from that type of information. Next slide. Another new development, and I'm sorry, next slide. Here we are. Another new development that we can discuss briefly is the New York Fair Chance Act. And again, different states have different ways of addressing it. It's often described as ban the box legislation. And generally, it prohibits an employer from refusing an applicant based on criminal history unless there's a direct relationship to the criminal offense and the job sought, or the employment would involve some unreasonable risks to property or safety or welfare. And you must consider a number of factors in New York in particular, including the age of the time of the offense and the time that has lapsed since the offense and the seriousness of the offense. And then you must engage in a detailed process before determining if we're going to act on criminal history. And we could do an entire CLE on this alone. But just to give you a brief overview so that I can then give you the updates, I'll say that you're required as an employer to have affirmatively ask the applicant to provide information relevant to each of the factors that are outlined in the law, and undertake an analysis of the information that's provided, and then provide that written analysis to the applicant and give them time to respond. Before the amendment, it was 3 days to respond. And then that analysis and the response must be then reviewed again by the employer. And during that time, you have to keep the position open during that response period and allow, as I said, the applicant time to supplement additional information. And then there's a process by which, if you decide to revoke the employment offer, you have to give notice of the final decision. And there are also parameters if the employee or the applicant, requests information outlining the details of that decision and when you must provide that information. So there is a very long process by which you have to, analyze and really narrowly tailor a decision to deny an applicant a job and tying that to a particular job function if it's based on a criminal history. Next slide. So there have been amendments to the New York City Fair Chance Act, and that those are effective July 28th, 2021. And here are quick highlights of those amendments. The first is that the process will be extended to pending arrests and other pending criminal accusations. In addition to that, and I will say that that has been something that's gotten a lot of attention given the number of arrests and detentions this past summer, given the number of incidents of civil unrest in New York in particular. So that has gotten a lot of attention extending into pending arrests and criminal accusations. In addition to that, it extends to employers seeking to rescind a promotion or a transfer or to end the employment of a current employee, so not just job applicants. It also is extended to independent contractors and freelancers. And there's a prohibition on inquiring about criminal history at any time. That's certain criminal history, I should say. And those are things like violations, non-criminal offenses, pending, non-pending arrests, criminal accusations, youthful offender adjudications, and certain sealed offenses. So it really starts to narrow the areas or the circumstances under which criminal history can be used and carves out certain types of offenses that can't be used at all. In addition to that, it adjusts the fair chance factors. So it adds more things that the employer should consider, including explicitly noting New York City's policy to overcome stigma towards the unnecessary exclusion from employment of persons with criminal justice involvement. And then also it expands the applicant response time from 3 days to 5 days, and explicitly notes that an employee can be placed on unpaid leave for a reasonable amount of time while the employer is conducting a fair chance process assessment regarding a criminal conviction during employment or a pending arrest. And with that, I will hand it off to Aaron, who will discuss some of these nuances in Washington and take us on to other topics.
Thanks, Shevon. Today, I'm going to cover Washington's new non-compete statute. I'm also going to say a few words about Washington's new paid family and medical leave law. which has some pretty important implications for people with folks employed in Washington. And finally, I want to say a few words about labor and employment law in Washington recently and some general trends I've been observing. So we go to the next slide. Washington has passed a new law governing non-compete agreements that's pretty restrictive. This is a trend we're seeing across multiple jurisdictions across the country. Legislatures are passing laws limiting the ability of employers to enter into non-compete agreements, and courts are also tending to be more critical of non-compete agreements and requiring employers to show a more compelling interest before enforcing non-compete agreements. This new statute doesn't apply to non-solicitation covenants, so employers still have more freedom to operate there. Only true non-competes that prohibit an employer from even working for a competitor are covered. Under this new statute, a non-compete agreement is unenforceable unless its terms are disclosed before the employer accepts employment. And this is a common feature. We see something like this in a lot of these new statutes. Oregon, for example, requires that the non-compete be disclosed a period of time before the employment begins. The non-compete, if it's given in exchange for an increase of compensation, it has to be disclosed ahead of time as well, and the employer has to let the employee know that the non-compete may be enforced against him or her in the future. This new law requires that employees be making at least $100,000 a year, and that amount is adjusted annually for inflation. Otherwise, the non-compete is unenforceable. Also, if an employee is laid off, for example, because of a position elimination, the employer has to pay the employee's base salary for the duration of the non-compete. But note, this doesn't apply to situations where employees are fired for example, poor performance. There's also a presumption that non-competes over 18 months long are unenforceable unless the employer can prove by clear and convincing evidence that the non-compete over 18 months is necessary. And as a practical matter, this means that employers aren't going to want to try for non-competes longer than 18 months, given how punitive the statute is if you don't follow any portion of it. Basically, if the court has to modify the non-compete in any way, there's some potential for some pretty serious damages, which I'll get into in the next couple of slides. We could move to the next slide now. Employers sometimes try to use choice of law provisions to evade non-compete statutes like this one, especially where the employer is headquartered in a different state. And we saw this for a while before this non-compete statute was passed in Washington. There were some cases dealing with what happens when you have an employee in, say, for example, California, and you have a choice of law provision selecting Washington's law. There was a period of time there where maybe you could get a non-compete enforced in another jurisdiction by using a choice of law provision. Well, jurisdictions are closing that loophole, and this now includes Washington. If you pick a venue provision outside of Washington, it's going to be invalid under the statute. And if you have any provision in the non-compete agreement that is contradicting this particular statute, this statute will control. So if you try to take away any of the employee's rights under this new statute, the statute's going to say that Washington law will apply. There's a real interesting provision in here too that applies during employment, not just post-employment. And this is somewhat unusual. Employers can't prohibit employees who make less than 2 times the state minimum wage from getting a second job, unless the second job would create safety issues. For example, if an employee was unable to remain alert due to working 2 jobs, or if the second job would interfere with the employer's ability to schedule shifts. So especially for lower paid employees, this can be an issue. As a practical matter, I usually recommend against having lower compensated employees subject to a lot of additional rules anyway. So if we could go to the next slide. Yeah, as I mentioned before, Washington's new non-compete statute has some particularly brutal penalties for even the slightest issue with the non-compete. If the court refuses to enforce the non-compete or even just modifies or partially enforces the non-compete, the employer is on the hook not just for the employee's attorney's fees, but for the employee's actual damages. And this can be really bad in situations where a new employer refuses to hire the employee because of the non-compete. Under those circumstances, the employer could be on the hook for the employee's lost wages at the new job for a reasonable period of time. Put another way, if you try to enforce your non-compete and someone loses out on a job opportunity, you could be paying for a year plus of that person's pay at the new job if you don't completely win your litigation. And, the challenge here is this applies if the court partially enforces the non-compete or modifies the non-compete or in any way doesn't just completely enforce the non-compete as written. So you can actually win a motion requiring someone to not work for an employer for a period of time, but then be subject to damages simply because the employer modified or limited the non-compete. So the bottom line here in Washington is you've got to be very sure you're going to win a non-compete dispute before suing to enforce a non-compete, given how tough the statute is. And employers should also keep in mind that courts are increasingly unwilling to enforce broad non-competes in Washington. There have been several cases where courts have struck down non-competes that broadly prohibited employees from going to work for companies that sell any competing goods or services. This is sort of a blanket non-compete. If someone's a competitor, you can't go work for them. Well, Washington courts have increasingly struck down those broad non-competes, and instead, courts want to see non-competes that are limited to only the goods or services that the employee in question worked on or had information about, or the products and services that employee sold. So if you have a company that makes 5 different widgets and an employee only sold or learned about one of those widgets, you really want to limit your non-compete to the one widget the employee worked on. Companies should also avoid requiring non-competes for employees who don't have access to real confidential and trade secret information or don't have any real customer goodwill relationships. People outside of those categories really you shouldn't try to get non-competes to apply to them. And, it's not always easy to do, but non-competes are most easily enforced in Washington where the employer customizes that non-compete for the employee's particular circumstances. If you've got sort of a blanket one-size-fits-all non-compete, courts are going to be less likely to want to enforce that. If the non-compete references the employee's particular job, you've got a salesperson non-compete, you've got an R&D non-compete, which is different, it's far more likely to be enforced in Washington. Gabrielle, while we're on the subject of non-competes, it might be helpful for folks if you wanted to say a few words about how California law is different.
Sure. So I think most people know that in California, for just a straight old employee, non-competes have been illegal for years. And California only allows a non-compete in connection with the sale of equity or shares of stock in the business where it's necessary to protect the goodwill of the business. But the risks in California are far broader than just having an illegal non-compete. There are actually 4 different ways that you can get in trouble for trying to have a non-compete in California. The first is Labor Code Section 432.5 provides that it is illegal to ask an employee to sign something that you know to be illegal. And the penalty is not just the damages that Aaron quoted under Washington law, but also that they can sue you under our Private Attorney General Act and collect additional penalties just because you ask them to sign something that's illegal. Our Business and Professions Code, Section 17200, does the same thing and allows an employee to sue you for an injunction to stop you from performing an illegal act. Our Labor Code, Section 925, states that an employee, unless they're actually represented by a lawyer at the time, cannot sign a foreign choice of law provision. So, for example, you can't try and get Washington law to apply to a California employee because you're not allowed to pick Washington law as the forum or the choice of law. And then finally, if you terminate someone for not signing the illegal non-compete, they can state a cause of action for wrongful discharge in violation of public policy. So companies that try and go overbroad and get a nationwide non-compete anyway, hoping to skate by the laws of all the various states, get into serious trouble in California.
Thanks, Gabrielle. Yeah, these are really important tips to keep in mind. A lot of folks in Washington were caught by surprise by the statute, in part because it applies to all non-competes whenever signed, not just non-competes signed after the adoption of the statute, which is what you've seen in other jurisdictions. Any claim that's brought to try to enforce a non-compete that's filed after January 1st, 2020, which would be all cases now, are subject to this statute. So important for employers to take a look at their non-competes in Washington and make sure that they're consistent with the statute. And also in California, think long and hard before even wanting to stick a toe in the water in regards to non-competes. So if we can go to the next slide, we can move on to our next topic. Washington, like several other states, has passed a paid family and medical leave law. And there's some good news for employers here, given that the program is administered by the state and funded jointly by employers and employees. Whenever you adopt one of these large, unwieldy programs that's new in a jurisdiction, you're going to have trouble with administration. You're going to have rules that don't cover all sorts of circumstances. We've already had, 6, 7, 8 regulatory phases here where new rules have been passed to try to explain ambiguities in the statute. Given that the Washington Employment Security Department is responsible for administering the law, that takes a lot of the liability burden off employers. And if something gets screwed up, employers can say, look, call the Employment Security Department. That's really good news. The bad news is that this statute, under the right circumstances, can allow employees to be away from work for over 6 months. And for some employers, it's really tough to have to provide 6 months of protected leave. A portion would be paid, a portion would not be paid, as I'll explain later. Fortunately, that's not going to be common, but there are certain circumstances where that could happen. So this new Washington law, it's actually last in 2019 is when the tax to fund the program started. 2020 is when the actual paid family leave program was up and running and people were starting to receive benefits. This new program pays up to 90% of wages for low income workers and pays up to $1,000 per week. Premiums are currently 0.4% of gross wages, with employees paying 63% of weekly premiums and employers paying the remaining 37%. There's an exception here for employers with fewer than 50 employees who don't have to pay the employer's portion. Premiums are capped at 2020 Social Security wage base of $137,700. So above that wage base, there's no additional premiums. And this statute kicks in for folks once they've worked at least 820 hours for any employer. Paid family and medical leave is in that way portable from job to job. Employees can use hours worked from prior jobs in the year to qualify for paid family leave later in the year. Independent contractors and self-employed workers may also elect coverage, and employers with 50 or more employees must participate if they have any Washington employees. And an employee is covered if the employee provides services to the employer in Washington, provides services to the employer in multiple states, and the employee's base of operations is in Washington, or if the employee provides services to the employer in multiple states and the employee's base of operations is in multiple states and the employee resides in Washington. So there's a long reach here for the statute. Go to the next slide. Family leave is for situations where family members have a serious health condition or to bond with a newborn or newly adopted child. Family members include a child, spouse, domestic partner, parent, parent-in-law, sibling, grandparent, or grandchild. Medical leave is for an employee's own serious health condition. And what you get under the statute is you get 12 weeks of family leave or 12 weeks of medical leave or a combined total of 16 weeks with a possible 2 extra weeks for pregnancy-related disability leave. So a grand total of 18 weeks. And if we go to the next slide here. The law here allows employees to potentially string together quite a bit of leave. The statute says that federal family and medical leave, FMLA leave, runs concurrently with Washington PFML, but it doesn't state that Washington PFML runs when an employee takes federal FMLA leave. This means that an employee can choose to take first 12 weeks of FMLA leave under the federal law, and then have up to 18 weeks of additional job protected leave under the Washington Family and Medical Leave Act. Another issue that happened over the last year, there have been substantial delays by the state in providing benefits to employees. This has started to improve, but it's still a potential issue. This led to a lot of frustrated employees and employers who ended up providing benefits to employees who were left in the lurch. If we can go to the next slide. There's a real key concept here that employers need to think about with employees in Washington, and one that if they don't can really have some bad consequences. The statute allows employers to designate certain leave benefits like PTO or company-funded parental leave as so-called supplemental benefits. And what this means is when the employee tells the Employment Security Department how much money they're making, they don't have to include these supplemental benefits. So those supplemental benefits won't count against the employee's entitlement to leave. If you don't designate these benefits as supplemental benefits, then the employee will report, PTO money coming in or other forms of paid leave funded by the company against the employee's right to payments under the Washington Paid Family Leave Act, and their benefits will be reduced. So it's really important to properly designate these benefits as supplemental benefits to make sure your employees are getting everything they're entitled to. Go to the next slide. So I wanted to end with a couple of observations about labor employment in Washington State. I start every employment law training with the same rule that I call Goldstein's law, and it's just don't be a jerk. One of the best things companies can do to reduce liability in employment law is to demonstrate in their words and actions that they're committed to the success and well-being of their employees. And I'll tell you, especially in the Seattle area, this is really important. Judges and juries want to see employers who demonstrate their commitment to the success of their employees. And employers that are callous or act callous or have written communications that look like they're designed to check boxes, or worse, designed to outfox their employees, those get you in real trouble. And so whenever you have any written communications, whenever you have discussions with employees, you always want to ask yourself, does this communication demonstrate that you're committed to your employee's success? Or does it look like you're just trying to outfox the employee, or worse, insult the employee? Judges and juries are human beings, and they are invested with a lot of discretion under our legal system. L&E is often about narratives, and you want to make sure your words and deeds create a narrative that reflects well on your company. I also want to say a little bit about a trend I've seen over the last 5 or 6 years that's become increasingly important, and that's that public relations concerns are starting to outpace liability concerns in some situations for how serious they are for companies. Customers have grown increasingly concerned about the moral implications of their purchases. You might recall the situation where Fox News paid a lot to settle several cases against Bill O'Reilly, and it wasn't until sponsors started pulling their ad buys that Fox canceled the show. And this is really a situation I see a lot of companies needing to take into account. It's not just, are you going to get sued, but are there public relations concerns that are raised by taking on this particular case or by fighting really hard in this particular circumstance? Sometimes even if you think you can win a trial, you have to consider the PR implications of proceeding. I also want to say a few words about the last several years and the series of unprecedented events that we've all been dealing with. We've seen rapidly changing state and local rules for controlling COVID-19 in the workplace. We're having to apply old tests for discrimination and retaliation to entirely new circumstances involving COVID-19. And we've also had to face unprecedented political division. When you're in uncharted legal territory, decision makers, judges and juries and investigators, have to exercise a lot more discretion because there just simply aren't as many legal precedents. And, this is sort of circling back to my first point. You want to always show that you are acting with good faith in your employees' best interests at heart, especially when you're doing any kind of performance management documentation. You always want to record that you're taking steps to help your employees succeed. And finally, the last point I want to leave with is the concept of at-will employment is really just becoming theoretical, especially in Washington state. For every termination, it's going to be scrutinized for some sort of appearance of improper basis. It's very rare anymore that an employer can simply fall back on at-will employment, given how easy it is in the vast majority of cases to point to some improper basis for a termination. In the Seattle area, at least, at-will employment has become a theoretical concept that rarely applies in practice. And with that, I'll turn the presentation over to Gabrielle.
I have 12 minutes to tell you everything you need to know about California law. Just kidding there. What we're trying to do today is to highlight for you the fact that the states all are taking very different approaches to the topics that we're covering. And in the old days, 10 years ago, you could assume that if California did something and you complied with California law, you were probably okay everywhere. Well, as Aaron just pointed out to you, Washington now provides more paid leave than any other state, including California. So you need to take that into account if you're trying to design a nationwide policy. The first thing we want to highlight for you in California is just to remind you, we do have our own paid sick leave program, which is the first bullet. But more importantly, on March 29th, the governor reactivated California's supplemental paid sick leave that applies to COVID. And two important things. Number one, you're required to put the accrued amount of paid sick leave for COVID purposes on the pay stub in your first pay period following March 29th or now. That it's retroactive. So they will have earned as of January 1, 2020. And it's still 80 hours for full-time employees and the average number of hours for part-time employees. This expires in September, but in the meantime, you're required to provide it. And it still is subject to the cap you saw last year of $511 a day or $5,000 in the aggregate. So you need to take care of that with your payroll provider. The second thing we wanted to point out on the next slide is that California has expanded its paid family leave. And while Washington is paying for 12 weeks of leave, California now is paying for 8. So while we were the pioneers that started it with having this coordinated with the Unemployment Insurance Fund, other states are exceeding what we are allowing in terms of paid family leave paid for by the state. We want to highlight for you that Colorado is also becoming one of the forefront laws that they have paid sick leave. They have, and the next slide, they have reporting for salary purposes. They have all sorts of laws that exceed or equal California's. So if you're a multi-state employer and you have Colorado, please take a look at it. Colorado's law is fairly similar to California's. They allow, if you have to provide it if there are 16 or more employees. California, it's everybody has to provide it. And it can be for the employee's own condition or family members, similar to California's. The next slide will highlight for you the topic that we wanted to bring up today of website accessibility. This is one of the most complicated areas of law that we're seeing on a nationwide basis. In California, so the issue is whether or not your website has to be accessible to people with disabilities under the ADA. So can someone who is impaired from a sight perspective, can they use a screen reader to access it? How would someone who is hearing impaired access your website? And California, of course, is one of the states that had some of the broadest rulings. In the Robles versus Domino's Pizza case that came down in 2019, the court held that Domino's was required to make its website accessible to people who were impaired from a sight perspective. And they applied the WCAG standards that are not regulatory standards, but industry standards to say that you need to have an accessibility program. And the court held that the only limited part of the ruling was that in order to have your website be something that had to be accommodated, it had to accommodate people with disabilities, the business had to have a nexus to a physical location. So if you're only an online store under the Robles decision, it's an open question whether or not it will apply to you. But in this case, it said because Domino's used its website in order to place orders and get deliveries, it was a public accommodation because there was a nexus to a physical place. So the 3rd, 5th, and 9th circuits all agree with this, which means that across the country, there's a speckled group of rulings saying that if you have a website, it must be accessible. As the next slide will show you, other states disagree. So Colorado doesn't have a ruling yet, but there will be one. There's one plaintiff has filed at least 52 lawsuits since December of 2020 against companies who have websites. In Illinois, Illinois has ruled there is no nexus to a physical location required. So even an online store with no Domino's store that's delivering or making pizzas can be required to be compliant. And the Illinois ruling is a Seventh Circuit ruling that applies to Indiana, Wisconsin, and Illinois. As the next slide will show you, and a really surprising development that just came down this month. So the 11th Circuit had said that websites were places of public accommodation. And some of the first trials took place in Florida with results that were not favorable to employers. The 11th Circuit reversed these and said that a website by itself is not a place of public accommodation, and that plaintiff's inability to access the website didn't violate Title III of the ADA. And the court's rationale was here that it didn't constitute an intangible barrier to access to and being able to enjoy the goods and services provided by Winn-Dixie because it had limited functionality and was not a point of sale. So the problem that's created by the decisions that have come down are the Winn-Dixie facts arose in 2016. Since COVID, most places are now a point of sale on their website, and many businesses have started to run their whole business through the website because of COVID. So you're going to see a lot more action in this area and many more lawsuits. We wanted you to be aware of that. Salary history. We had a discussion about salary history with Shevon's presentation on New York law. And we wanted to remind you that Labor Code Section 432.3 in California had previously been enacted, which provides that an employer can't seek or rely on salary history. Although the law does say that you can listen if it's volunteered, if we go back to the case law that started this all, you will see that it's probably a really bad idea to use prior salary history for anything except for salary history within your own organization. And then the one thing the law does require that most employers have had trouble with is on request, you must provide a pay scale for the position. So that just has to be the range of salary or hourly wage for the position, not necessarily bonuses or equity pay. In contrast, look at Illinois. So Illinois now has said that you actually have to have a pay registration certificate where you have paid a filing fee and submitted an equal pay compliance statement, which takes your EEO-1 form and adds on a list of employees by gender, race, and ethnicity and report their total wages. Far more comprehensive pay equity statute than anywhere else in the United States. And 5 or 6 other states are looking at enacting the same thing. And the penalty is that you will have to pay 1% of gross profits if you haven't got your pay equity statement. So to our point, pay attention because other states are enacting these laws. On the next slide, you'll see that we do have some states that are going the opposite direction. Michigan and Wisconsin have forbid any local entities from having any sort of a local ordinance that would ban an employer from asking about salary. So, but if you step back and look at the laws that started it all, which of course usually starts in California, as we'll see on the next slide, in the Rizzo case, the US Supreme Court held that prior salary can't be used to justify a gender wage differential in an Equal Pay Act claim. That if you're using prior salary, you're merely perpetuating a wage gap that already exists, and therefore it's perpetuating discrimination. If you look at it that way and you say, why do I need to know prior salary? You can see how just theoretically in any state, the argument is that if the only basis for the pay differential is a prior salary and the prior salary was set in a discriminatory manner, then you have engaged in discrimination. So watch these state laws as they continue to evolve, but understand that these are the issues that will get you into trouble in California. The one thing I did want to note, Shevon talked a little bit about the Crown Acts that just were enacted in New York, and other states have followed act, and that is you can't discriminate against anybody on the basis of their physical appearance, such as hair or other things that may be tied to race or ethnicity. That existed in many other states, including California, and was part of just the general prohibition against discrimination on the basis of race. So even though the Crown Acts are sometimes being called out specifically in other states, you need to understand that in many states, discrimination on the basis of having afros or having any sort of racially identifying hair or dress were already protected categories under the state discrimination laws. And finally, throughout the nation, you've seen a variety of statutes enacted that address pay data, pay discrepancies in order to enforce all these laws that have to do with salary inequities. In California, that was SB 973, which hopefully you've complied with as of March 31st. It requires private employers of 100 or more employees nationwide who have at least one employee in California to report pay data, including hours worked, EEO by EEO category, which would be sex, race, and ethnic background. The regulations are on the screen. They're contained at dfeh.cal.gov, and there's a form that's pre-populated there that you can use to fill out your data. The data won't be publicly available, but will be used by the Department of Fair Employment and Housing for enforcement purposes. And right now, there are exemptions from the Freedom of Information Act so that it shouldn't be available to a plaintiff in a lawsuit against you. However, with the introduction of all these various pay reporting requirements throughout the nation, you should expect that your employees may well ask you what average pay for the positions are when they're applying for a job, and that the plaintiff's bar will try and get that information from you if there's a discrimination lawsuit. Do check the laws of Colorado, for example. They've got a similar statute that was just enacted last year that's brand new. And this is an area that we expect to see continued developments in. So stay tuned for next year. We appreciate you coming with us to hear this today and hope that this has helped you identify some of the issues that may get you in trouble on a nationwide basis. Thanks for attending.
All right, important stuff. Depressing, but important. 3 down, 1 to go. We're going to take about a 9-minute break. We will be back at 11:40 for our last panel to get you up to speed on all things remote workforce related. See you soon.